People seeking out estate planning services often hear from friends that everyone should have a trust. In my opinion, there's almost no legal solution that's right for everybody, and this includes the conventional wisdom that everyone should have a trust. Even for people who tell me they don't have much, the myriad of family, financial, tax, age, health, business, and other considerations that go into a comprehensive estate plan are unique to each person or couple. It's therefore important to work with an attorney who gets to know you as individuals and tailors a plan unique to you. Now, there are some people to whom I will usually recommend will-based estate plans and stay away from trust-based estate plans. Will-based estate plans are typically less expensive, but my reasons for not recommending a trust are not necessarily cost-based, but are instead usually outcome-based. It's important for you to work with someone who helps you achieve your goals rather than simply sell you an estate plan. The reasons for why will-based plans are better suited for some people are as varied as the clients who visit my practice. But let's say take 3 examples and look at 3 examples of these types of people for whom will-based estate plans are maybe more appropriate. Number 1, Medicaid applicants. Clients who are very likely to apply for Medicaid, which is a long-term care public assistance program, should consider will-based estate plans. In order to qualify for Medicaid, it's often financially beneficial to have certain types of assets outside of a trust structure and owned in an individual capacity. By avoiding a trust altogether, we avoid the administrative hassle of removing assets from the trust in the future. Number 2, active farmers and ranchers. These clients are often very wealthy. However, many of the farm subsidy programs run by the federal government, and also programs having to do with land management, disaster relief, or weather relief payments, are dependent on the form of ownership of the farming operation. Now, critically, the factors governing how these programs function are embedded in detailed federal regulations that few people even know how to find, much less take the time to read. Active farmers and ranchers who participate in such programs risk restricting their access to claim benefits from these programs if they blindly follow the advice of an inexperienced estate planner or a document preparer and just place their land or equipment into a trust. This is less of a risk for farmland owners or retired farmers who are strictly landlords and only rent their land to operators. But active operators must be very cautious when developing their estate plans to avoid disqualifying themselves from government programs. And finally, number 3, people who have de minimis estates. Say people with a net worth of a few $100,000 or less and maintain only a few bank or investment accounts, typically will not need a trust-based estate plan if they intend to simply pay out the proceeds of such accounts to their heirs. It's not that these people don't need an estate plan for other reasons, such as to manage decision-making or medical care during a period of incapacity due to physical or mental illness or dementia. Rather, it's that administrative hassles of a trust may overcomplicate an estate plan and lead to inflated costs. If someone thinks they're not wealthy enough to need a trust, it's important to note that wealth is only one component of determining whether or not a trust is appropriate. A professional estate planning attorney can guide you through the other considerations and help you decide. Now, this video isn't intended to be an exclusive list of who should or who should not include a trust in their estate plan, but it hopefully highlights the diversity of factors that need to be considered before making such a determination. I'm estate planning and tax attorney David Gerszewski. Thank you for watching our video blog.